to go out and protect these people. The federal government is seeing to that. They're prosecuting the Panama unit. Why would you want to go out there and talk to drug dealers as well? The Panama unit, what they do, they broke into your house, they stole your drugs, they stole your money. If that's the job that you want me to do, I'm sorry, I'm not gonna do that. I'm not gonna waste our taxpayers' money looking for glory headlines. I'm not. That's who I am. That's what I will be, if you give me the opportunity.
Thank you. Mr. Rodriguez, 30-second rebuttal.
Again, these victims, not only were they victims of these crimes, but they're individuals that have information. They're individuals that can, that the state can work with and try to get information from them, find out what else was going on. Were there other officers involved? Were they the only ones that were involved, the ones that were arrested? I mean, there's a lot of information on these files that could have been taken from the district attorney's office. The cases were already there.
Thank you. Now we're going to dial back a little bit. We're asking some very hard questions, so now we want to get the basic of what each candidate feels personally. So, Mr. Guerra, what has been your protocol for first-time misdemeanor offenders?
Back in 2004, the state allowed us to have pretrial diversion program. A pretrial diversion program is where a young person gets arrested, usually under the age of 25, with some exceptions. Gets arrested on a first offense. You can have that person taken to court, which I do, under my authority. You file a case, they come before the court, and if they have a chance to rehabilitate, we have them plead guilty in court, we suspend the sentence and we put them under court supervision. They pay an upfront fee of $500, and then they pay probation fees to help pay the probation officer, because no public monies can be used for deferred for pretrial diversion. So the fees that they pay on a monthly basis are used to fund their salaries. If the young person is successful, whether he be a college student, a high school student, or a young person looking for a job, if they are successful, then the case is dismissed. 2 years under DPS policy, possibly sooner, they can hire a lawyer to have that case expunged from their record, and they can compete for jobs. Those pretrial diversion programs came into being in about 2004. One of the tragedies I see on a daily basis is some lawyers, or court-appointed and others, who may feel like they're not compelled to request these pretrial diversion programs for the young people. They go out and plead guilty. Some of them come to me later wanting to have those cases expunged. Well, it's too late. The pretrial diversion program that we have for saving these young people is there for a purpose, and that's to keep them from themselves. There are some drug offenders that we drug test over and over again, trying to have them qualified, because if I put a drug offender on pretrial diversion, within a month he's going to be revoked, and he's going to go to jail, or he's going to be convicted.
Mr. Rodriguez, same question.
Individuals who are first-time offenders in misdemeanor cases should always get an opportunity to try to better themselves. And if they better themselves, then we better society. We get them back on track to make sure that they educate themselves, or they're back with their families, so they're being productive to society. There are programs available at the DA's office, just like Mr. Guerra talked about, the pretrial diversion program, where it gives individuals an opportunity to have their case dismissed at one point. After so many months, they complete a program, they go through classes, they get randomly drug tested, they pay a fee, they pay a fine. They get that opportunity to have the case dismissed. I just want to make sure that everyone gets an opportunity to get the case dismissed. I've seen sometimes where there's individuals who can't afford the fine, can't afford the fee. It makes it difficult for some individuals that don't have those monies. We just want to make sure that we give everyone an opportunity that has the same situation, the same offense. I know it's a case-by-case basis, but we want to make sure that we give each individual an opportunity to be on that pretrial diversion program, to have an opportunity to get their case expunged and not have it on the record. So that way they can further educate themselves. They won't have a problem finding a job down the road to support their family. We just want to make sure that every individual gets that opportunity. We want to make sure that the attorneys know that, that they have an open door policy where they can come in, whether it's the DA's office or directly to myself, where they know that they can come and reach out and ask for help for their clients that deserve this opportunity to have the case dismissed as to the case that's pending. But again, we just want to stress that we want to make sure that everyone has an opportunity to get on this pretrial diversion program so they can have the case dismissed and eventually expunge their record so they won't have a record.
Next question. Mr. Rodriguez, what would be your protocol for first-time felony offenders?
Well, as the overseer of a drug court for about 5 years, this drug court consisted of first-time felony offenders of a drug offense or a drug-related offense. And it was a great program because it gave them an opportunity to get counseling, to stay drug-free, to meet with probation department constantly. We made sure that they were productive in society. We made sure that they didn't pick up any other offenses. Made sure that they were working. Made sure that they were with their families. This program was for 18 months, and it was a great program, which I was the overseer. And it gave individuals an opportunity, again, to dismiss their case at the end of the day, and also to have their records expunged. And it's very touching because now I see a lot of these individuals who are out in school, out working, that were part of this drug court program, and they're doing excellent. The state of Texas has been pushing for these type of programs. They talk about rehabilitation. They're getting away from a punitive mentality as to first-time felony offenders. They're creating DWI courts, veterans courts. In Dallas, they have a prostitution court. Why a prostitution court? Because, again, they're giving these individuals an opportunity to be in these programs, take them out of that revolving door, in and out of jail, and it saves taxpayers dollars at the end of the day. But for first-time felony offenders. And again, this is a perfect opportunity to help these individuals when they're in this drug court program. Now, in this drug court program, when I was there, I got help from probation department, different organizations that were involved in this drug court. And the prosecution, Mr. Guerra, I wish you would come down and talk to me and say, what else can I help you with?
That is time. Mr. Guerra, same question.
There cannot be a pretrial diversion program without my say-so, or the district attorney say-so. When I first heard about pretrial diversion authorized by the state, it was limited to only certain select cases. Looking at the situation of young people offending in felony cases, where they could be ruined for life if they got convicted, I opened up other offenses to pretrial diversion. I went out on a limb. People are easy to criticize that you're not equal across the board. I'm being criticized by my opponent about that. Now, the drug court existed because I bought into it. Not that it was only judicially created, it was created through the discretion of the district attorney. In some counties, the district attorney supervises the people. I chose to go through the court system because I wanted to make sure that I would not get accused of only certifying or qualifying political supporters of mine. I opened it up to the courts and I gave them the leeway through my prosecutors to qualify people for pretrial diversion. Now, when a person gets convicted, a young person gets convicted of a felony, they can kiss the rest of their life job-wise because nobody's going to hire a felon. Now, without the discretion of the district attorney, this would fail. I've supported pretrial diversion programs. I don't want to ruin UTPA almost graduates who have invested thousands of dollars in their education, and then they got caught with 1/4 of cocaine. Pretrial diversion programs exist to help some of these people, but they have to qualify. They have to do their part. Now, those that don't have any money, then why violate the law? Okay? I'm sorry, there's some qualifications. Some fees are necessary to fund the program. Thank you.
That is time. Mr. Rodriguez, 30-second rebuttal.
Just want to make sure that the community in Italian understands that we want to give first-time felony offenders the opportunity to be either in the drug court that they qualify, or a pretrial diversion program that they qualify as well. So they can have the opportunity to have the case dismissed and eventually expunged, so they won't have any problems down the road with their families or work later with school.
Thank you, Mr. Guerra. Mr. Rodriguez, sorry, guys. Continuing on with the drug case questions, given that Washington and Colorado have already taken steps to decriminalize marijuana, and given your personal experience with prosecuting cases, would decriminalizing marijuana be beneficial to the Rio Grande Valley? Mr. Guerra?
It would be devastating to the valley, to you, if you decriminalize the use of marijuana. I think Colorado and Oregon and those states that are authorizing open use of marijuana are going to pay the price down the road. There are medical studies, CAT scans of brains that are taken, and other medical exams that show that the functioning of the brain when people use marijuana is reduced because it is a depressant. They take the same instrument for the people that are using cocaine, and you see hyperactivity. And you can see these on the internet, and you can look at some of the medical studies. Now, why is a cocaine addict, if you look at a cocaine addict, why is he with sunken eyes and almost skin and bones? The reason is very simple. The drug has taken over the body. It has stopped the functioning of the judgment of the brain. When the stomach wants to eat, it sends a message to the brain, we want to eat. The narcotic stops the message center from receiving that message, and the person goes hungry, doesn't feed the body, and you have the results. Methamphetamine is a deadly drug. It works for about 6 months, make you feel superhuman. Within 6 months after it controls you, your life is going to wither away. You're going to age at a tremendous pace. Now, drugs are dangerous. Some of you in the audience and some other people may think it's crazy. But I know that when marijuana stops giving you the effect that you want, people will go to cocaine, they will go to heroin, they will go to methamphetamines. They have some problem in their life, and before you know it, they're going to go into a district attorney's office for us to handle. I have seen this for 31 years in law enforcement.
Thank you, Mr. Guerra. Mr. Rodriguez, same question.
Being the overseer of the drug court for 5.5 years and being on the bench for 6.5 years, I see where individuals, especially in the drug court program, where they start their use with marijuana. From there, it escalates to cocaine. And from there, it escalates to methamphetamines. And we've seen the effect it's had on individuals. And if it's going to have this effect on individuals, starting with marijuana, it's going to have an effect on all our society, all our community. Because I've seen it firsthand as the overseer of the drug court, where these individuals, these kids, start with marijuana, and it just escalates and it escalates. And I've seen kids in the courtroom where you ask them, how did you start, when did you start using drugs? I started using marijuana. That's how it started, and it just escalated to cocaine, to methamphetamines, and anything else that was out there that was available to them. So yes, it would not be good for the community, and especially for the individuals who start off on marijuana and have this thinking that, well, it's only marijuana, it's going to stop there, it's not going to go any further. But I've seen it where it does go further. It goes cocaine, methamphetamines, and anything else out there that they can get their hands on at a certain point. So it would not be good for the individuals, and it's not going to be good for, it would be good for a community.
Thank you. No, this one's a little long, so bear with me. One of our members came up with this one. Texas is known for its defense of the Second Amendment, the right to bear arms. Specifically, Texas allows citizens to apply for a concealed handgun license. Let's set up a scenario. An individual with a concealed handgun license witnesses a crime against a third party, and in the course of following proper protocol, kills the assailant and injures the third party. Mr. Rodriguez, how would you handle that case?
It's a case-by-case basis, fact-by-fact basis, but just because one carries a concealed handgun doesn't give him the right or the authority to kill someone else. There has to be some grave danger at that certain point where someone has to use a weapon to protect themselves or protect others. But you know, there's been many cases where individuals have defended themselves that have a concealed handgun, and they feel that just because they have this concealed handgun, they can use it at any time they want to. I mean, we're not in the Western days when somebody can take out their gun and shoot whoever they want. I mean, they have to feel that there has to be a grave danger to themselves or to someone else to be able to to use their concealed gun at a certain point.
Thank you. Mr. Guerra?
If you look at the Second Amendment, the right to bear arms really applied to the militia back then, when we had no central government. Now, I believe in the Second Amendment, the right to bear arms. In Texas, we have allowed concealed handgun privileges. But with that privilege comes a great responsibility that you cannot exhibit and you cannot use that deadly weapon because you feel that you're justified. Now, if a person takes out a weapon and shoots in trying to save somebody that's having a difficult situation, third party, the question that I first have is that one, which one is the assailant in that fight, and who's the victim? So if the person reacts and uses a weapon to try to prevent a major crime where maybe deadly force is being applied, that person's under a tremendous responsibility to ensure, one, if he's going to use it, he better use it accurately. He cannot shoot an innocent person. He cannot go, oops, I meant to do the right thing, but I killed an innocent. The law of transferred intent may apply. If he's reckless, he's going to be prosecuted. He should be prosecuted. I don't know about being prosecuted for murder, but his conduct has to be evaluated with the best investigation possible. Now, when you're acting in self-defense, the law will give you self-defense, and you will not be prosecuted. I mean, I have been prosecuted in the past, but people were clearly acting in self-defense or in defense of their property at nighttime. The right to bear arms does not give you the privilege to shoot innocent people. Thank you.
Thank you. Our next question. What has been your protocol when dealing with victims of crimes against their families? Mr. Guerra?
You have several types of domestic violence. You have abusive elderly, where the young addict, drug addict, is demanding that their older parents fund his addiction. They become aggressive. You have spousal abuse, both men and female, men and women. You have boyfriend, girlfriend. You have these kind of violences that we have to look at. Now, the problem that I have in our handling of these cases, that's not really a problem. The problem is in the investigation of these cases. Who's telling the truth? Who's willing to go to court? And whether they want to stay the course. Domestic cases, assault cases, are difficult to prosecute, especially when the victims are not willing to cooperate. Many cases, the officers react to a call. The victim does not want to file charges, but under the law, the officers are authorized to segregate the alleged assailant or the one who's assaulted, to take him away, and oftentimes they arrest them against the wishes of the victim. We have to deal with those cases at the courthouse. What we do is most of these people are taken before a judge, and they're still willing to drop the charges. We have no choice. When you have thousands of cases that you have to prosecute, you have to dedicate your resources to the people that want to go forward. This is a very difficult situation that really has no correct answer. Nobody can say, I'm going to be aggressive on all of domestic violence. It's not possible. when you have unwilling witnesses who disappear on you. It's gotta be on a case-by-case basis with cooperating witnesses.
Thank you, Mr. Guerra. Mr. Rodriguez, same question.
It is on a case-by-case basis, but if we have the facts, we have the evidence, we have an offense that's been committed, then yes, we go aggressively and we protect domestic violence. Again, it is on a case-by-case basis, and what happens sometimes is it starts at the municipality or at the county where, you know, we have someone who is a victim of domestic violence. And we do have individuals that write up a report, an affidavit, and then when the case is submitted, then they don't want to come to court, they don't want to present themselves. There's several calls that are made to these victims, and again, there's no response. But on cases that are well put together, and the facts and the evidence are there, and they're ready to be submitted, and we have a good case, then yes, definitely we will aggressively go after domestic violence cases.
Thank you. Would you like to do a 30-second rebuttal?
Yes. If a fight occurs at home with only 2 individuals there, that case is put together, is well put together. But in the absence of somebody who can testify under oath, the case is hearsay, it's rumor. You cannot go forward. You can't be aggressive. You have to be practical. Those cases oftentimes have to be dismissed, even though it may leave a bitter taste in the prosecutor's mind. Where you have a person
Thank you, Mr. Guerra.
dropping charges over and over again.
Thank you. Mr. Rodriguez, we have a very good group of veteran students coming back to school. And in light with the new studies coming out of PTSD and domestic abuse at home, how do you what is your protocol when dealing with potential PTSD defendants or assailants?
Well, the state has given us the opportunity, and it created a veterans court, which is here in Hidalgo County. And I want to tell the community and the residents of this county that I'm a big supporter of the veterans court. A lot of individuals who are in this program are individuals who have the same effects and the same illness that they've gotten from serving our country. I want to say that these individuals are victims of serving in our country, and this veterans court gives them an opportunity to be in this court at their first time felony offenders, and gives them an opportunity to stay medicated, gives them an opportunity to function, gives an opportunity to counsel. Sometimes it's said that it's an excuse that they use, or they're just using these illness to get away with the crime, but we have to take it on a case-by-case basis, and a lot of these veterans do have these illnesses and have these effects from serving our country. And again, this is a great court that should be utilized for these individuals who come back with these illness from serving our country.
Thank you. Mr. Guerra?
I'm a veteran, but in looking at what happened after Vietnam, we had a high incidence of drug use in Vietnam because it was a terrible war. Now, I don't recall a lot of those veterans who may have come back and violated the law that we had any special treatment for. And they were just as terrible in combat as the ones in Iraq and Afghanistan and all the other areas where the United States has armed forces fighting evil. Now, in having a veterans court, which I support, in having a veteran arrested for a violent offense against a domestic partner, a family member, or a stranger, what you have to establish is whether this veteran can really establish the condition that he claims is defensive in nature. You just cannot say, because you were a veteran, we're going to give you a carte blanche. Not on violent offenses. You may do it for drug offenses. You may do it for other minor offenses that don't have an actual victim. But when it comes to an actual victim, the defense lawyer is obligated to present the defense on behalf of the veteran. It's not the job of the DA to go out and establish it. The district attorney's office is to consider what is being proposed, what's being presented to the court, and then to establish a protocol in some situations as to whether we're gonna be more lenient in the prosecution and the sentence recommendation than possibly another individual who is not a veteran, who has not been in war, not been in combat, may not have that kind of consideration. We cannot just give blanket authority for veterans who come back from war to maim and violate the rights of others.
Thank you, Mr. Yes. Mr. Rodriguez, 30-minute rebuttal. 30-second.
If the opportunity is there to help these veterans when they come back from serving our country, which they meet that criteria for a veterans court, then so be it. They should be given the opportunity to be in the veterans court. I'm not saying that if a crime is committed by a veteran, that's the excuse that they can use to have the case dismissed or get away with the crime. I agree. The defense attorney has to do the job as well at a certain point where they're the ones that have to defend their clients, defend the veteran.
Mr. Rodriguez, how many campaign workers have you hired for your campaign, and how much money have you spent on your campaign?
I've hired many campaign workers on my campaign. There's 1 million people who live in this county, and we've hired many campaign workers to do a lot of work for us in this campaign. It helps us spread the word. It helps us spread the message. And these are the type of campaigns that we're doing all that we can to make sure that we get the message out and we have enough help, all the way till March 4th.
Thank you. Mr. Guerra, same question.
Since I started back in 1982 in my first campaign for district attorney, being the low-funded candidate, I depended on volunteers, barbecues and what have you to fund my campaign. I've established a decision over the other campaigns that I would not go out there and ask a lot of money from people that would come before the district attorney's office in decision-making, maybe defense lawyers, and others that might have particular interests. I've depended on over the last 8 campaigns, mainly for volunteers. Now, in this campaign, I've given money for some phone banks. But these are people that are calling. They're not going out the street and getting elderly folks and taking them to the polls and to assist them in the polling where they vote instead of the elderly people voting. That's an abuse, not only of the Constitution, but of our law. Some people are paid hundreds of dollars to assist disabled individuals, either at home or in the actual polling place, where they go and assist under the law that are allowed to assist. Some of these people are getting paid $5 and $10 a vote that they can deliver. I do not believe that. I think it's against the law. The unfortunate thing is that I cannot prove it at this time, but I will try. Now, let me send a message. People that are volunteers that go knocking on doors, soliciting and influencing voters is legal. What's illegal is the person who goes into a polling place and actually votes for somebody by telling them, if you want to vote for this person, we need to mark out the other person. And they actually deliver the vote for the person that they've been hired to pay, to deliver.
Mr. Rodriguez, 30-second rebuttal.
All the campaign workers that we have on our campaign have not been paid for votes. They've been paid to work this campaign and to do all that they can up to the date of March 4th. Ricardo Rodriguez's campaign is not about buying votes, not about abusing the elderly. As a matter of fact, a lot of these campaign workers that I have today have helped Mr. Guerra in the past, many of them. But Ricardo Rodriguez does not have these campaign workers to do any of that, to break anything.
Thank you, Mr. Guerra. Mr. Rodriguez.
Two.
Two. Mr. Guerra, what is your protocol for prosecuting employers who refuse to hire union employees under the Taft-Hartley-Texas Rights to Work law?
Wow. I don't know any case that has been arrested or